Well, good afternoon. My name is Mary Crowley, and I'm president of the League of Women Voters of North County. On behalf of our league and the League of Women Voters of San Diego and Common Cause, we're absolutely thrilled to see you today. And we're especially pleased that this wonderful attendance due to a rainy, miserable Friday afternoon. And that certainly implies you agree with us that this is really, really important. For members of the League, this panel discussion is part of a study update on the initiative and referendum process. In 1984, the League of Women Voters California adopted a position supporting the citizens' right of direct legislation through initiatives and referendums. Despite the position being updated in 1999, we all know only too well much has changed in how this process has progressed. That is why League members at their last state convention in May of 2011 agreed to once again update this study. This update process will conclude at our convention this year in May. We're just thrilled to have such a distinguished panel and moderator here with us. We would also like to extend a very warm welcome to those of you from the community who have joined us, and an especially warm welcome to the Carlsbad High School AP government class who are here. So before I conclude, I just have one housekeeping task, and I'm only pleased there's only one. I've been asked to inform you that this meeting this afternoon is going to be filmed. And now I would like to introduce the co-president of the League of Women Voters of San Diego, Jeanne Brown.
Good afternoon, too. And I, too, have one housekeeping. If you haven't already silenced your cell phone, please do now. And welcome. It's great to see so many people. I have the distinct pleasure of introducing someone who is near and dear to all of the League members. When Mary Thompson and I, from the North County League and our league, started talking about having this forum, we discussed speakers, but then we said, well, who's going to moderate? My first thought was Mary, because Mary has been involved with this so much, been living and breathing this for the last couple of years. And she said, oh no, we want to go for the gold. And who is the gold but Trudy Schafer? Trudy, for those of you who are not in the League, is the Senior Director for Program for the League of Women Voters. She's been a League member since 1978, served as president of her local and county league, and then as the state legislative director before joining the League staff as the lobbyist in 1992. Yes, the League has a lobbyist, and so not all lobbyists are evil creatures. She works on a broad spectrum of projects, both in citizen education and in advocacy. Her focus has been on advocacy on League priorities at the Capitol, as well as on a number of ballot measure campaigns, including redistricting, campaign finance, and budget reform measures. In 2001, she represented the League as a member of the Speakers Commission on the California Initiative process. So with all that said, I would like to introduce the League's Gold, Trudy Schafer.
I've never been quite described that way, but I'm certainly taking it home and informing my family about it. I do want to say that this is an exciting topic and a very exciting panel. I think that we're in for a great conversation, because the more we talk beforehand, the more I realize we should hear quite a few different views, as well as some of the more prosaic things that the League members are going to be asked to weigh in on as you all meet. I think it's in March to actually report back to the state committee that's looking for a consensus on statements of our position on the initiative process. As you know, leagues all around the state are doing this sort of thing, and I had a newsletter article from the Alameda League up in the Bay Area, and I thought that this was very typical of what I think we're all struggling with. they had a speaker, law professor Michael Salerno from UC Hastings College of Law. And this is one of the things that they quoted him as saying: "I'm not against direct democracy. It's California's version of direct democracy that I do not support," he said. "The initiative process in California does not yield good results the way it is presently structured. I am a strong believer in direct democracy, just under conditions that do not currently exist in California." And then after the quote, it goes on to say, "Voters often complain that California's initiative and referendum process no longer works as it was intended to in 1910. Costly initiative petition efforts and ballot measure campaigns put the initiative process out of reach for most citizens. Ballot measures are often flawed and too complex. And with 90% of state spending predetermined by the conflicting revenue and spending requirements of numerous voter-approved initiatives, the legislature only controls 10% of California's annual general fund budget." People might quibble about those numbers and even about what the problem is in its entirety, but I think this sets the stage for what it is that we and our panel are going to be grappling with. So to turn to the panel, I'm going to try to hit some of the highlights of the bios that are in your program, and I'm doing a little more talking than I intended to, but they're just such impressive people that I couldn't resist. Our first speaker is going to be Bob Stern, who is the second to my left on your right. He is the founder and president of the Center for Governmental Studies, an institution that did unfortunately close in 2011. He helped found that in 1983 after being very involved in government, the way government functions, both in the legislature, in the Secretary of State's office, and with the Fair Political Practices Commission. And he was the first general counsel of the FPPC, in fact, after writing the law, helping write the law that formed our Political Reform Act. And he's the one who wrote the book. I'm waving the 39-page executive summary of Democracy by Initiative, Shaping California's Fourth Branch of Government, and this is the second edition. Bob's got the inch-thick real thing. And so I want to ask Bob if he could kind of set the stage for us. The Center for Governmental Studies, and Bob, in much of his speaking, and he is a league member, he's spoken to many league groups, about what he sees as some of the most challenging issues confronting us in these next the next many years. All in 3 minutes, if you can do it, Bob.
Well, thank you so much for inviting me to be here. I have been a league member for 20 years, a member of the Santa Monica Malibu League of Women Voters, and I've been on a league tour. I spoke last week in Santa Barbara, to the Santa Barbara League on the initiative process. I appeared twice in the Los Angeles Leagues, 2 meetings they had this last week. I was in Irvine a few days ago speaking to them, and I'm going to Burbank next week and speaking to the league there about the initiative process. So I'm learning a lot from members, and I really appreciate the feedback. The theme of our book, Democracy by Initiative, is we believe that the initiative process should be preserved, but it should be improved. And we had several recommendations on how to improve it. Thad will talk a little bit about this, but the people have more confidence in the initiative process than they do in the legislative process. So as you're considering amendments to the process, think about that. The people are going to be very, very reluctant to change the initiative process unless they think it would help. I'm going to give you 2 challenges that I'd like you to think about as you're doing this. Name me an initiative that passed in California that the voters said, whoa, we made a huge mistake the next day. There are very few times where the voters have passed initiatives where they have regretted passing. Now, I can think of a few, going back a few years, that they will change. For example, Prop 8 passed by, the ban on gay marriage passed by 51%. That, I think, in 4 to 6 years will be repealed. But at the time, I think the majority of voters agreed with that initiative. So voters are very rarely, if ever, fooled into passing initiatives. They are fooled into defeating them, but not passing them. The second thing I'd like you to think about is how can we improve the qualification process? I think the process we have right now is maybe the worst process to qualify an initiative. If you have $3 million, you can qualify any initiative. If you don't have $1 million or maybe $750,000, you can't qualify any initiative. So we need to do something about improving the process of qualifying initiatives, perhaps using the internet as one way to do it. Certainly, I would increase the number of days to circulate initiatives to a year. Right now, it's one of the shortest in the country, 150 days. Also, I would not change the single subject rule. Single subject rule says that the initiative has to contain one subject. The Political Reform Act covered campaign financing, lobbying, conflicts of interest, and the ballot pamphlet. If you change the single subject rule, the Political Reform Act would have been 4 initiatives instead of 1. I wouldn't sunset initiatives. What that would mean is more on the ballot. Sunsetting means the initiative should be repealed after 10 years or 20 years, and it goes back on the ballot to see if the voters would like it. I don't think you want more on the ballot. And what initiative would you sunset today that's out of date? I'm not sure. But consider the indirect initiative proposal. We'll be talking maybe a little bit more about that, where the initiative goes to the legislature first. The legislature gets to consider it. If the proponent and the legislature can work something out, take it off the ballot. That would happen, in my view, about 15% of the time. You'd need 1 or 2 fewer initiatives on the ballot. I would suggest to the League that they change their position on contributions and spending limits that they have in their. Right now, they say that there should be realistic contribution and realistic spending limits. I agree there should be. The Supreme Court does not agree with me or with the League. The Supreme Court has declared them invalid, and you can't have them. Finally, add a page to the ballot pamphlet. On one side of the page, there would be a list of the people who support the initiative, on the other side, people who oppose the initiative. Most of us, when we consider initiatives, look and see who's supporting and who's opposing. And one more thing. Remember that most of us don't distinguish between initiatives, referenda, bond measures, measures put on the ballot by the legislature. They're all ballot measures. And so when we're looking at the process, we need to look at the whole process, look at how the legislature puts things on the ballot as well. So those are just some of the thoughts I have. I'm sure we'll get into a few more. Thanks so much for inviting me.
Thank you very much, Bob. And I must say, I've got notes of things that I hope we'll get a chance to talk about, and Bob has really touched on many of those issues. So we will be circling back in many ways, I'm sure. But first, let's hear from an introductory statement from the rest of the members of the panel. Second speaker will be the person just to my left, Glenn Smith, who is a professor of law at California Western School of Law here in San Diego and a visiting professor of political science at UC San Diego. He has sought after opinions in a number of different areas, including constitutional controversies around the Supreme Court. He has spoken on free speech issues and privacy considerations. And what I thought was especially interesting, and I heard this certainly from my hosts of the San Diego and North County Leagues, is his work with his students to really bring the study of law to practical terms to people, bring them into those thoughts into people's lives. In particular, he has a seminar, a well-known seminar, in which law students learn about the Supreme Court by playing the roles of the justices and the people who present to them. And he also has worked on the applicability of the kind of notice and comment process we have for regulatory decisions, and whether there's a deliberative method that can be applied to how California makes its laws by direct democracy. And I can wave, I was just given today. He's published all of these. I've got a couple of law journal reviews, and well, from different universities. I love this last title, More D, Deliberation, for California's DD, Direct Democracy, Enhancing Voter Understanding and Promoting Deliberation Through Streamlined Notice and Comment Procedures. So with that, would you please speak to us, Professor?
Sure, thank you. It's really my pleasure to be here. This is, I told them at lunch, I feel like I'm in high cotton, as I used to say, where I grew up. And this is a very distinguished group, and this is obviously a distinguished audience, so it's a pleasure to be here. Although I spent, not surprisingly, as a law professor and a lawyer, I'm wordy, and I've certainly written at great length. But my message today is very simple. I've summarized it in a double-sided piece of paper that's in the back. And I really have just two basic points I would like to introduce into your thinking about this. The first is that I really think that the League, legislators, anyone who's really serious about doing what Bob said, which I think is great to make the initiative process more workable, needs to focus more on deliberation and making the process, improving the information that's available and the opportunities for people in a useful and informal way to discuss the merits of it. I'm not saying ignore the other, improvements on signature requirements and timing and all that, but I think that deliberation enhancement is really the sleeping giant of initiative reform that you all would do well to do and we all would do well to focus on. I say that, first of all, because substantively it's very valuable. however we fix the initiative process, it's going to inevitably be with us, and it's going to require voters and people that give cues to voters, like your organization, to have really top quality information, a real good sense of what the initiative proposes to do, and a sense of what leading thinkers about the topic think are its pros and cons. And practically, I've noticed, I've studied 14 years of legislative proposals in the recent past to try to improve the initiative process. And I noticed that both Republicans and Democrats governors tended to veto anything they thought was an attempt to limit the initiative process or coming from an anti-initiative process approach. The advantage of deliberation proposals is it doesn't have to be pitched as something that's against the process. Let's slow it down, let's make it not work, let's make it less accessible. It says, look, let's make it work better. Let's have voters make decisions that are more informed. I mean, and as a state legislator, I try to discuss it. Who can be against a more informed voter? You know, and people that give them cues. So I think both substantively and practically, it's an area that's ignored to an extent and has a real payoff. The good news is that there is an existing process which we use when regulatory agencies make law. After all, they often make rules and regulations that are the law, the governing law. And because there's no legislative process, California for decades has had a process where the proponents of a regulation issue a notice saying, here's what we plan to do, here's our legal authority for it, here's what we don't change, here's what we do change, and had an informal comment process, and then come back and explain why the final proposal responds or doesn't respond to those proposals. So the good news is there is an existing informal notice and comment proposal that can be streamlined down, made not judicially reviewable, and a few other things that would need to be changed. But we have a model that works pretty well and could be used to bring a lot more deliberation to a process that ultimately needs to be highly deliberative, because we, for better or worse, make all kinds of important policy, economic, and other decisions. So thanks.
Thank you, Professor Smith. I was not quite fair to my panel. I happen to have with me Bob's executive summary, and I was given Glenn's academic papers. I did not warn Thad that I would like some paper to wave at you, but I will tell you that if you read the bio, you'll be very, very impressed anyway. I think of him as somebody who's sort of young. He got his PhD in Berkeley in 2002, but we are 11 years later, 10 and a half years later, and he's an associate professor of political science at UC San Diego. His interests sound like a compendium of League of Women Voters' interests, as well as he's on the state board of Common Cause. I mean, listen, term limits, the initiative process, voting by mail, reapportionment, campaign finance laws, the blanket primary, healthcare policy, and maybe not so much for us, the European Parliament elections. But at any rate, you are a distinguished professor. The bio mentions books that he has written, and most recently in 2012, The Power of American Governors, which I'm sure is interesting. And I mentioned that you're on the State Board of Common Cause, and so I know from the work that the League does with Common Cause that that means you have both a practical as well as a philosophical, theoretical take on the politics in California. So.
Well, thanks so much, Trudy, and I'm so glad that you're doing this panel and that all of you have chosen to spend your rainy Friday with us, because your time is not wasted. Something might actually happen with initiative reform in its 101st year, this year or most likely next year, and we're leading into 2014, because there are really four major efforts to look at an overhaul of the initiative process. Now, we've had these before in 1999 with the League, and many of them have gone nowhere, but there's a lot of momentum this year. There's the League's process, which I think will be very important. Common Cause is leading a process, a meeting of stakeholders every month in Sacramento, sort of a diverse array of interest groups who are looking at these issues. The legislature is looking at this very seriously, and with a 2/3 supermajority, one of the things that does is it gives that Democratic supermajority the power to put things on the ballot before voters. And so many legislators, and many of the most powerful legislators, are looking hard at serious reforms to the initiative process. And then finally, and most entertainingly, we have California's the homeless billionaire, who actually Joe has written about extensively. This guy named Nicholas Bergruen, who doesn't live anywhere because he lives on his private jet, but he's someone who has a lot of money and cares a lot about California, and pledged $20 million to spend on political reform initiatives in California. He created a group called Think Long. He's worked closely with the retired Supreme Court Chief Justice Ron George, who wants to reform the initiative process, and I think they will be coming out with some ideas. So there are a lot of ideas in the hopper. What I want to do as a political scientist, just to set up this discussion, is to talk about where the end game is. The end game is any major reform to the initiative process. The big ones are going to have to change the state constitution. So they're going to have to go before the voters and win a majority of the vote. So what do we know about what the voters like about initiative reform? We've done various polls with various academic groups and folks, but probably the most indicative was one called a Deliberative poll on constitutional reform, which was a process kind of like this. 400 randomly sampled people actually got together. They read a 100-page manual that some of these folks at this table helped us craft about the initiative process and other issues in California. They spent a weekend together in Torrance, California, debating with each other, debating with experts, and then they were polled about what they thought about initiative reform. So I just want to quickly read you the results of this poll, not to say these are good or bad ideas, but to give you an idea of where the public is right now. And to emphasize one general theme, which is that there are a lot of ideas that will fly with the public as long as they don't let the legislature get its dirty, stinking hands on the initiative process. A lot of my favorite ideas for changing the initiative process would allow the legislature to get its stinking hands on it, but voters don't like those. So here are the things that voters liked. Publicize the top 5 contributors for and against each ballot measure in the ballot pamphlet. Everyone loves that, 91%. Require all ballot measures that require new expenditures to say how they'll be paid for. Gives more information to voters, 85%. Glenn Smith's idea, propose a formal review process to allow the legislators, proponents to get public input and say what their initiative does, 76%. Make the threshold needed to pass an initiative the same as the thresholds that the initiative requires of the public in the future, so the public can impose a 2/3 vote requirement without getting a 2/3 vote. That actually gets supported. It gets 2/3 supermajority support. Allow an initiative's proponent to withdraw it after it qualifies for the ballot. Sure, people like that idea. Right? Those are the ones that win. Here are the ones that lose. Allow the legislature to amend a measure that's already been passed, subject to public review and the agreement of the initiative's proponents. So even if you do this in public and have the initiative proponents agree to it, the public says no, only 37% like it. Allow the legislature to remove an initiative from the ballot by actually enacting it into a law? No, only 37% like that. Allow a simple majority of the state legislature to place a countermeasure to an already qualified initiative on the ballot right next to that. So this is what Switzerland does. They put it, the legislative alternative right next to it, just gives voters more choice, 30%. And then finally, allow the legislature to amend an initiative subject to a 2/3 vote, even if the initiative's proponents don't agree with it, fix a problem that the proponents don't want fixed. No, 18%. So a lot of what we're going to be talking about, and I think for good reason, is bringing these two separate processes, representative democracy and direct democracy, together, but there will be a big electoral hurdle towards doing it. Thank you.
Thank you, Pat. And I wonder if League of Women Voters members, if not everybody in the audience, if you're thinking community education, citizen education, we're good at that, we can do this. But we have to know what it is we want to do, and that's the reason for being here today. Our fourth speaker is John Mathews. I think that many of you may know him as a reporter, a blogger, an author, and are familiar with his work. In the world of direct democracy, he is director of Arizona State University's new Global Direct Democracy Academy, and he's co-president of the Global Forum on Modern Direct Democracy, and they have an interesting website. They've had several, must have been 3, 4, major international forums, the most recent in Montevideo, Uruguay. With co-author Mark Paul, he is, I get to flash this now, the author of a book called California Crack-Up, How Reform Broke the Golden State and How We Can Fix It. Many of you are probably familiar with this, and many more of you would have to be enticed by that title, and certainly you will also by the content of it. Joe is also the California editor of Zócalo Public Square, which puts on informational programs and forums and it held a program about the initiative process, one of a couple, one in Los Angeles last year, at which I was a panel moderator, and it had the wonderful, catchy title that is used here today, Do We Have to Take This Much Initiative? Joe will probably comment about democracy, direct democracy around the world, but also, of course, we're counting on him to join and maybe be the biggest touch of controversy to some of our discussions, but not necessarily all of them. I will share with you that in a planning phone call we had, he said so many ways to skin this cat. Almost all are better than our current process. So, Joe.
Thank you so much. I'm honored to be here. I feel a little out of place. You have three distinguished thinkers and scholars and journalists. To be very brief, I just want to make you all aware, profoundly aware, that while this is very much a California conversation, I hope it doesn't stay one. There is a big conversation going on around the world and around the country about how to make this process better. I hope you'll use what other people are doing. In the three other states that have had the most initiatives in American history besides us, Oregon, Colorado, and Arizona, there are groups from the Center for Arizona's Future to Charlie Brown at the University of Denver to Tyrone Reitman and Tony Accarino at Healthy Democracy Oregon, who are trying to figure out some of the same things that we're doing. And there are people all over the world. The Europeans have a new initiative process. There are all sorts of people trying to figure things out. Bulgaria this weekend has its first ever initiative vote on nuclear power. And they're wrestling with some of these conversations. People are trying to figure out these things, and I hope as the study continues that you look at what other folks are doing, in part because almost every other model that I can find in the world looks a lot better to me, at least, than California's. We do some things very well, particularly in voter guides, but that's it. I hope you'll have the benefit of meeting those people, and I'm happy to be making introductions and point you the way if that will help the League. I'm also a League member in Pasadena and the surrounding communities of the West San Gabriel Valley, and I'm very glad to see you doing this. An honor to be here. I've been doing the League tour, it feels like, for a couple of years. But then I want to start, I want to sort of agree with most of what folks said, except for that on process, from which I want to say almost the exact opposite of what he told you, which is I would not start by thinking about 2013 or 2014 as a moment of initiative reform. In fact, if you look like you're going to sign up for initiative reform in the next year or two, I would urge you to stay away and not do it. I think that notion of there's a year of initiative reform, there's a moment, and we're going to do it with a couple ballot initiatives is sort of kind of the California disease. It's how we've gotten into the mess. And initiative reform, if it's going to be true reform, can't be done just on initiatives. You just can't do surgery this process. Our basic problem is we have three systems in California, sort of governance and fiscal management system. Our legislature does some of that work. We have election system, we have an initiative system. They don't fit together. Real reform involves tying those things together. Doing many things at once is something that cannot be done in the initiative process. It requires deliberation. It requires some sort of constitutional revision process that gets us there. And I think the spirit, and what concerns me about this, the League process and sort of setting down positions as the League does, is that you're going to sort of lock yourself into certain things. And I don't think you want to lock yourself in. I think you want to have a big, broad discussion, look at all the different models and possibilities out there, and then start changing and experimenting. The core problem, one of the core problems in California is we're very inflexible as a governing system. It's very hard to change things. You want to create, through some process where you can try change the initiative process, see for a while how they work, and then change them. And that should be sort of the philosophical approach. And then I just have to, one completely reportorial historical note that I would like to offer in this room, because it bothers the heck out of me, and I've seen it in League documents, an error it makes. People in my profession make it. We're really the ones responsible. We've spread it. But it's a history thing. Every story about the initial process of California says there was this holy beginning where the people wanted noble things and to bring the people back. No. It was some ugly people who also were into eugenics and a lot of strange things, who had been in big political fights in San Francisco, most of them. Governor Hiram Johnson, who basically didn't want the legislature to be able to touch initiatives because his dad had been a corrupt legislator and they didn't speak. I mean, it's always been a kind of rough, expensive process, and almost all the problems we see in it today, they're not new revelations. People saw them in the first decade of the process. And so please don't repeat that mistake. I'm trying to reach the reporters so we don't lazily throw that paragraph into our stories as well. But anyway, let me stop there, and thank you for having me, and I'll try to be on my best behavior.
I may like you if you're not, but thank you very much. And actually, you've given me a chance to comment about where some things are on the League's website, and I would like everyone to know that www.lvvc.org is the State League of Women Voters website. The C is for California, and you will find information about this study on that website. Look for the initiative study. We do have, I guess I'm a thwarted teacher, I guess. Our study guide was written by the committee that Mary Thompson is part of. Initiative and Referendum in California, A Legacy Lost, was actually the title of the study guide back in the 80s, and it just continues to be a very appropriate title. If you read that, I will have to say in the committee's defense, Joe, there's better history than the very simplistic, but I think we also do gloss over, especially how it was used in those first decades and so forth. It's just, I think, since Prop 13, everybody pictures that it's so much worse, and some of the statistics really are about the use of it and the money spent and so forth do seem to be getting worse. There is also a members-only League of Women Voters led website, and that has on it the consensus questions, which League meetings in these next months will be addressing as they try to put together a report of their discussions for the committee. I already mentioned to try to bring together and see where we have consensus. So that leads me to one of the questions in that set of consensus questions is aimed at something this committee wanted to do in their study that we don't always do, and that was to try to come up with things that are more timeless, that can be the principles, the values, the general concepts that would allow us to address issues that we haven't really ever seen, or technologies that we haven't seen, whatever does come about in the next however many years it needs to last. That won't be easy. I can't promise that it's going to work very well, but the last question, or one of the last questions, is in fact about what values, what principles should be the most important ones, and we broke it down into at what stage in the process. I'm going to ask for a lightning round here, of would you each tell me one value that you think is especially important for us to bear in mind as we look about what is the value of the initiative process, what should be kept in mind as we think about reforms? Glenn, you're the sorry person to go first.
Yes, to repeat myself, I just think deliberation and information and an opportunity to make sure that people are able, those voters, those few of us that actually read the information and try to educate ourselves as much as possible, but more importantly, the people that we'll be getting our cues from, as Bob said, can just get as much information and hear as many points of view about initiatives. It drives me crazy as a lawyer that people say, well, we just passed this thing and we're not sure what it does. It seems to me that we ought to at least be able, all of us, to know before we vote what the intention of the drafters is to do, and then what some people that really know about this area think about it.
Thank you. Bob?
Well, I guess I'll repeat myself also. The initiative process should be preserved but improved, as should the legislative process of putting measures on the ballot.
So to me, the initiative process is all about representation. So there are a lot of things that are ugly about the process, and there's money, and there are people getting paid that we may not like. But at the end of the day, I care about whether policy outcomes fit what voters want. And so all of the reforms that I think are important would give you better information, help voters make better decisions, and with that one end goal in mind.
Thank you.
Well, I would say integrating with all the different pieces of government, but I already said that, and I don't want to repeat myself. So I would say the value would be haste makes waste. California and actually the United States do this way too fast. It's an American, we do this like we're eating, fast, fast, fast. And when you sort of look around the world, we have only 150 days to gather signatures, for example. The process of our initiative is done very, very quickly. There isn't a lot of depth that goes to deliberation. A lot of countries you see 12 months, 18 months. The Floridians actually get this right. They give you 4 years, which actually gives real opportunity to qualify for grassroots folks to qualify measures. That's why we never have real grassroots measures. So I think time is a big topic that is overlooked in initiative discussion.
Thanks. And I will take us to one of the more specific aspects of the committee's work and the league's work, but you've really all set this up very beautifully. Generally speaking, I would say much of the discussion about the initiative and the referendum process is about issues about, should we make it easy to use? Should we make it harder in order to discourage people from using it rather than to encourage grassroots groups and so forth? And it often comes down to really, are people thinking that they would like to get rid of the process or keep it and try to reform it? But thinking of this in terms of putting up barriers or making it easier for the process to work, we did want to look at some of just the basic ideas about the process in California, partly because the existing position that the league members of a little more than a decade ago chose to write has some very specific things. I think basically the question was, what do you think about the current requirements for gathering signatures, for time, number of signatures, and so forth? And our members said, they're fine. So our position actually outlines that those are the ideal. Well, we'd rather come up with some principles, some general ideas, but I will couch it in terms of what do you think? And the question does say the current, should a position, for example, with a specific percentage of signatures be retained? Right now the law is to qualify an initiative that makes a statutory change, not a constitutional amendment, requires that they gather enough valid signatures to be equal to 5% of the number of votes that were cast in the last gubernatorial election. And if it's a constitutional amendment, you have to gather 8%. So in 2012's ballot measures, that was about 500,000 signatures that had to be valid, so people would, for a statute, that means that they would probably gather 700,000 or 800,000 signatures, just to be sure, and 800,000 roughly to qualify an initiative that's a constitutional amendment. So again, you'd gather 1 million or more signatures. So that's one general idea. Is that a good number? Should we be trying for easier, harder? Maybe is this not a relevant question? Similarly, would you do anything about the number of days that are given? Joe pointed out, I think it was Joe or that California is on the very short end of the requirements if you look at other states. So we've almost worked this to the ground, so please, some very quick answers about how you would like to see things changed, and would you have any advice for the group? And we're going to start in the middle, maybe, with that.
Okay, so I think the obvious answer to the question of should this be easier or harder is, well, you want to make it easier for the right initiatives and harder for the wrong ones, right? Easier for our ones, right? So that's very flip. But what does that mean? Well, I think if you use that idea and you know, one thing you could agree on is people are worried about paid signature gathering and the role of money in initiatives. The courts have been very clear that they're not going to stop paid signature gathering or people from donating to initiatives. So that's going to happen. $3 million will always get you your way to the ballot. What about those initiatives that have some real grassroots support but only $250,000? What's a way to help them get to the ballot? And there I'd have to agree with Bob and Joe that giving a longer period of time for signature gathering will help those grassroots, but not otherwise increase the number of initiatives on the ballot. Because if you got $3 million, you can get it in 120 days. Doesn't matter. 4 years won't lead to more of those initiatives unless you have more money. So I think that would be a fine thing.
And Joe, another chance.
I'm reluctant to answer this question when the person who knows more about signature gathering than anyone on the planet is sitting in the room in the third row, Mike Arno, who has done this in this state and all over the country and even overseas, helping the Russian opposition with ballot access, and those are tough campaigns. But my view is a little bit of that. I think we should think about the different kinds of measures on the ballot. There are initiatives for statutes, there are initiatives for constitutional amendments, and there are also referenda. Those numbers are actually fairly close together in California. It's 5% of the number of votes in the last gubernatorial election for referendums, initiative statutes, 8% for constitutional amendments. I would be inclined to, in part to save our crowded constitution from trouble, to make it harder to put constitutional amendments on the ballot and easier to get statutes and referenda on the ballot where we're talking about law. We have too much in Constitution and more in law. I also think time is a factor, and I also think we should make this discussion bigger. There's no reason that signatures have to be the qualification standard for getting on the ballot. I mean, there are deliberative processes that could serve, and Glenn can talk about this as an expert in this, that could serve as a way to get on the ballot. In Oregon, there's a process that's now used for the ballot guide If you could convince a citizens jury or some percentage of citizens jury that something's worthy of getting on the ballot, I like that idea. Think long, which Thad mentioned, the crazy homeless billionaire, my buddy, Nick Vergruen. I mean, they have a plan. They would create a appointed 13-member commission. It's kind of a weird proposal. It's eerily similar to the makeup of the Jedi Council in the Star Wars movies, but and they lost in the Empire. I just remind you. But it's a body you could go to. They would be empowered to put things on the ballot, and that would allow someone without spending any money at all and having a good idea conceivably to go to a body and put things on the ballot. I mean, I think there's a lot of conversation to have here, but making some things easier and some things harder, and really designing the pieces together is the key.
Thank you. Coming around to this side, Glenn, would you like to add anything?
Just very briefly, I agree with most of what's been said. As a constitutional law professor, I do think it needs to be harder, and really we have to think long and hard before we vote, put on the ballot constitutional amendments and adopt them. I think we need a higher requirement. You have to get them passed, say, in 2 successive elections or 2/3 vote or something. But generally, I think that ease of getting on it is great, and the bigger issues really are about, okay, you have to go to the legislature first, and what does it take to pass it?
Thanks. And Bob?
Well, remember realities. If I have $3 million in a terribly drafted initiative, I can get on the ballot. If I don't have $500,000 or $700,000 and have a wonderfully drafted initiative, I can't get on the ballot. Now, remember also one thing, only 1/3 of initiatives pass, so my terrible idea may get on the ballot, but it won't pass. Secondly, if we make it harder.
Bob, excuse me, can you all hear Bob in the back?
Maybe
just
just
went
went
off.
off a few seconds ago.
That's
I
right.
don't think they liked what you were saying. They turned their mic.
Try that.
I got all these microphones here. Okay, should I start over again in the back? Did you hear anything I said?
Most
Last
of us.
10
Just last 10 seconds, okay. Second reality is that if you make it harder for constitutional amendments to get on the ballot, what about what's in the Constitution already? We want to be able to amend what's in the Constitution already and not make it hard to do that. So I think that's a problem. And finally, I would raise the filing fee to put in this. Right now, it costs $200 to go to the Attorney General when you have an initiative. It costs the Attorney General and the various government authorities $6,000 to process your initiative. And only about 5% of what's put in right now makes it to the ballot. So let's make it harder. Let's pay for the cost of because anybody who gets on the ballot is going to have to spend at least $750,000 to get on the ballot, another million, at least up to $50 million to pass their measure. So making it at $6,000 is not a tough cost, but we should discourage all these frivolous initiatives that never make it to the ballot from having to go to the Attorney General's office.
Can I briefly get on that last idea, which sounds very good and I think is popular, is the kind of thing that's likely to pass, but actually subtly could make the process worse, and that's where I'm afraid this initiative reform thing is going. You'll get in a few narrow things that actually probably don't do much or do bad things. That sounds great, but there's very little flexibility in the system. You can't change things once you file them. It's very hard to change things when you file them, and most of the multiple filing in California at this $200 a pop is because people want to have some flexibility, so they file multiple versions and then choose one to go forward with. I mean, it's not the way I'd ideal it. I'd rather design more flexibility in the process. And so I would be careful of doing what Bob suggests unless you allowed for more flexibility and change in the front end, which I think Bob likes. Then adding that higher fee makes more sense. Again, it's the pieces fitting together.
But you would agree there are an awful lot that are turned in that never qualified. They're not multiple initiatives.
That's true, but sometimes there are ones that people just, a guy with an idea wants to make a point. Someone had a problem with Christmas music being banned at a public high school up in Reading and threw in for $200, got to make the point to the public, that they didn't think that was right, that it should be Christmas and not just a winter festival. I'm not sure that's such a huge problem.
And I've never heard of that. So.
Well, and I think that is an important point, that it's not a very transparent process until you get a little farther down the line. There are some of us who, and probably some of you, who get the watch on the website. Used to be you get an email from the Secretary of State or the AG's office about these things that have been filed. And indeed, many of them are like the Christmas music, and they don't go anywhere. So there are balancing acts everywhere.